as they continue to join. All right. Good morning, good afternoon, good evening to everyone joining wherever you're joining from. My name is Ide Dijkstal. I'm chair of the ICCBA's Victims Committee, and I'm very glad to welcome you to this important discussion in which we'll explore representing child victims before the International Criminal Court. Now, before we start, I have to note that this session is going to be recorded. We also ask that everyone who's not speaking turn their videos off while the speakers are giving their remarks. And then we'll move into a question and answer session afterwards where we'll welcome you to turn on your videos, and then you can ask questions through the Zoom or through the chat, either way. So over recent years, and particularly over the last few months, we've watched serious conflicts impact children. While the news has flooded us with updates of horrifying developments in Ukraine, where evidence is emerging of crimes directly impacting children, we must not forget that many other conflicts which have similarly impacted children exist as well and need to be addressed. This includes Syria, Yemen, Myanmar and Bangladesh, Palestine, South Sudan, and that's just to name a few, and is certainly not an exclusive list. It's a reminder that so often children are among those most vulnerable in conflict and most impacted by international crimes. It therefore seems fitting that we have a conversation with legal experts who bring significant experience in representing children, both domestically and internationally, and to discuss the challenges, the tips, and their ideas on best practices for representing child victims, so that before the International Criminal Court, we can aim to provide effective, efficient, and sensitive representation to children. The Victims Committee has aimed to bring together a group of speakers who can cover this topic not only by addressing child victims both domestically and internationally at those domestic and international levels, but also individuals who have approached this topic from the perspective of the prosecution, from ICC Victims Counsel and ICC support staff from the bench, and during investigations. It's hoped that these varying perspectives will help bring greater understanding and context to all those who go forward with representing children at the International Criminal Court. Now, before we start, I want to take a moment to acknowledge the other members of the Victims Committee who were also integral in bringing this program here today, and some of them who are with us on the Zoom right now. Along with me on the Victims Committee are Victor Salonis, Brian Kennedy, Elisabetta Galazzi, Elka Zapir, Stella Omiji Ideyamnim, and last but not least, to Sarah Rajasan, who we will be hearing from later as a speaker. Thanks to everyone's work in putting this together. Okay, let's begin. We'll first hear from the 5 speakers, and then we'll move on to the questions and answers. Our first speaker today is Dr. Shamla Alejandra Khan. Shamla is a Malaysian lawyer with over 24 years of experience. She has worked as a prosecution trial lawyer at the ICC, the Special Court for Sierra Leone, and before the Special Panel for Serious Crimes in East Timor. At the SCSL, Shamla worked closely with former child soldiers, both male and female, and led their testimonies in 3 trials. She served as the Assistant Director of Public Prosecutions of Fiji between 2018 and 2019, where she led prosecutions of child rape cases and secured the first life sentence for child rape ever to be imposed in Fiji and the Pacific. Shamla has also served as investigations team lead for sexual harassment and abuse with the UN Office of Internal Oversight Services. And most recently, she was the Gender and Child Rights Advisor to the Independent Investigative Mechanism for Myanmar. She has also represented accused persons as counsel at the ICC, STL, and ULEX Court in Kosovo. At the ICCBA, Shamla previously served as a member of the Victims Committee for 3 years and on the Executive Council for 2 years. So welcome, Shamla, and we look forward to your remarks.
Thank you so much, Heidi, and good evening to everyone. I believe that this is the very first time that the International Criminal Bar is engaging on the subject of child victims. The Victims Committee of the ICCBA and you, Heidi, as chair particularly, are to be commended for its leadership and vision, I think, in organizing this event. It is clear from recent public statements of the OTP that the dial on accountability for crimes against and affecting children has finally moved. And these crimes and this class of victims, children, will be increasingly prioritized in prosecutions that are going to be happening at the ICC. I think this makes this event even more timely and important to encourage the bar to be effective partners in this quest for accountability on behalf of children. A good place to start, I think, is always the OTP's policy on children. The promulgation of the OTP's policy on children in 2016 was a laudable initiative. It certainly reinforced the commitment made to children in the Rome Statute. It promises accountability for the wide array of crimes that children fall victim to. It promises to ensure that when assessing the gravity of potential cases, crimes against or affecting children will be regarded as particularly grave. And it also commits to incorporating the impact of those crimes into the analysis of the gravity of potential cases. Until very recently, these promises have been simply that, just promises. And in my view, they have not been fully translated into practice. I see somebody has a hand up. Did you want to say something? I'll just continue, just interrupt.
Yeah, perhaps we'll take all questions at the end, just so we can make sure to get through all of the speakers' presentations, but we look forward to those questions.
Thank you, Heidi. Now, we have seen in situation after situation that children are not merely bystanders, but are targets of almost every conceivable crime listed in the Rome Statute. Despite this, and despite the wonderful promises the OTP policy makes to children, child-specific prosecutions of the court have been quite limited, and it's been limited to child soldiering crimes, and more recently, the Taganda case, to sexual violence committed in that context. Those are indeed extremely grave violations. I am not diminishing their importance in the least, nor am I saying that they were not rightly charged and prosecuted. They were. What I'm saying, however, is that there is a wider array of other equally grave crimes that are inflicted on children, which also need to be a focus of investigations and which need to feature prominently in prosecutions before the court. Subsuming children into the wider civilian population or into gender categories for the purposes of charging sexual violence, I believe eclipses their unique suffering and victimization. Whilst the policy on children recognizes that particularity of the pain and suffering, to use the language of the policy, which is inflicted on children may amount to torture, this has never been charged to date. Despite the promise to focus on age-based persecution, this has similarly not been charged in any case as yet. The time has come, I think, to make the plight of children in conflict and war a priority in cases before the court. If you have missed it, I would really encourage everyone interested on this topic to please listen to the prosecutor's opening statement in the Darfur trial on Tuesday. His emphasis was the children of Darfur. It was remarkable, I think, that the array of horrendous crimes inflicted on Darfuri children and the impact of those crimes on them took center stage for the very first time at the ICC. And this was despite the absence of child-specific charges in that case. Like I said, the dial has moved. I think as counsel, I believe we can and must have a role to play in contributing to a more robust approach towards accountability for crimes against children. For example, using the mechanism for submitting Article 15 communications to the prosecutor, I think victims' representatives may make specific submissions with supporting evidence and legal analysis on crimes against children. Another avenue for counsel to represent children at the ICC is this. When seeking to represent victims in situations under consideration, victims' counsel should be increasingly vigilant to the rights, views, and concerns of children, and be increasingly willing to represent them as individual victims and as participants in these cases. We should actively find ways to make submissions on the crimes, as well as the impact of those crimes on children. We saw, for example, the tremendous value and the weight of victim submissions in the Bangladesh-Myanmar situation, when there was overwhelming participation by legal representatives for victims in response to the prosecutor's request for authorization to open an investigation pursuant to Article 15. Submissions were made, for example, directly to the chamber on behalf of Rohingya victims from Tulatoli, and the victims represented included 9 children. Now, these submissions were really compelling, and it urged the prosecutor to adopt a broad approach to the investigations so as to recognize the extent of the atrocities and to reflect the extent of the crimes committed. The filings also stressed the importance to the victims that the prosecutor investigated the widest possible range of crimes against the Rohingya. When describing the violations and the patterns of violence, I'm going to suggest that perhaps the submissions could have gone a step further and included more specific references to the experiences of the children in Tulatoli, and it could have identified the various crimes and which were committed against children and how the children were affected by those crimes. Building cases concerning crimes against children will not, of course, be dependent on children being interviewed or called to testify as witnesses. I accept that. But that does not mean they should never be interviewed or they should never be called to testify. We must respect and recognize and give effect to the right of a child to participate, and we must adopt bespoke approaches tailored to the interests of the child in accordance, of course, with the fair trial rights of an accused and provisions of the Rome Statute. I think it's important that we, as counsel, recognize and accept that children are capable of giving credible evidence, and that a child's age alone should not render him or her untrustworthy or unreliable. By assuming that children below a certain age will not have the stamina or the ability to withstand questioning in a criminal trial, what we are doing is in fact perpetuating, stifling social and cultural norms which say children are to be seen but not heard. I find that often discussions about interviewing children is either about a blanket policy that children will not be interviewed, or it is about what the age range of children to be interviewed should be. Now, I don't think we should set an arbitrary minimum age for victims that we will interact with. Instead, I think we should focus on having the capacity on our legal teams to be able to conduct forensic interviews of children. For example, counsel and investigators who have the practical experience working with child victims from all age groups. And then we must make an individual assessment based on the individual characteristics of the individual child. I find that very often decisions not to interview children are made because the expertise to do so is not available on the teams. One of the goals of a forensic interview, and Nicole will tell us more about this later, I'm sure, is to establish whether or not the child has the ability or the capacity to testify. Interviewers will question the child about his or her ability to distinguish between the truth and a lie. They may ask about the consequences of a lie and what the child understands about it. And through skilled questioning, interviewers will be able to know if the child knows the difference between what is real and what is make-believe. Very important in all of this is to be able to adapt our processes to the individual child and not require instead the child to adapt to our process. It is wonderful, I think, to have national experts like Justice Rajasinghe and Nicole Blumberg, with us here this evening leading the discussion. Through them, we will hear that with the right experience and employing the right techniques, young children can certainly come forward to tell their stories of horrors that they've experienced and how their lives have been affected as a consequence of those horrors. I've had the honor of appearing before Judge Rajasinghe myself and also other judges in trials that I've conducted at the High Court of Fiji, together with my Fijian colleagues, some of whom are also attending this event. And in those cases, charges were for child rape. In one of the trials I appeared before Justice Rajasinghe, the child victim who testified was a 5-year-old boy. In another, it was a 4-year-old girl. In other trials I prosecuted, the victims have also been very young girls and boys. With appropriate measures in place, a child-friendly courtroom, age-appropriate and child-sensitive questioning by prosecution and defense counsel, these children gave credible evidence, and they went through the process with full regard and respect for their well-being, very safely, and the rights of the accused were fully respected. There is no one-size-fits-all, and those who have experience working with children will be able to recognize that even if we are required to be applying interview protocols, be it the NICHD or the ABE protocols for children, an individual case-by-case, or shall I say child-by-child approach is needed. And we must think creatively to make it possible and safe for children really to take the lead in telling their story. In many domestic jurisdictions, there is still an imbalance in the expertise on working with children. Most often, the prosecution office will have the expertise in its staff, and it will conduct trainings on child-focused investigations and interviewing children. This expertise and training is always available and provided to the defense bar in some countries, like in my own in Malaysia it is, but it's not the case elsewhere. The harm that can be caused during cross-examination of children by untrained counsel cannot be understated, and there must be a requirement for training for counsel as well. I would suggest that the Victims Committee, that you have discussions with the registrar on having separate lists of counsel, legal assistants and investigators with experience in cases involving children and with experience in interviewing and examining child witnesses. I mean, such counsel can also be invited on an ad hoc basis to be part of legal teams in cases where the charges include crimes against children or where child witnesses will be called. It will also be helpful to include sessions on crimes against children in the annual council seminars, which are being organized by the registry and the ICCBA, and for there to be separate trainings and seminars for counsel to develop our skills to handle child witnesses. I think there is a lot we can learn from national lawyers who work on cases involving children, and these council seminars, I think, is a good opportunity for the exchange of knowledge and ideas. I hope that one of the key takeaways from this event will be that it is imperative that the bar approaches this category of crime and this type of witness in a way that comports to international standards and best practice. I would also encourage the chair, Heidi, and members of your committee to engage with the ICC prosecutor on his vision to prioritize crimes against children and to discuss how you can support efforts to mainstream the child-centered focus in every aspect of the work of the courts. I would also suggest that the Victims Committee, that you recommend a review of the current manual for victims representatives. Please correct me, but I believe the latest version was revised in 2019, and see how we can update it with a section dedicated to children. And related to that also, we can consider developing child-friendly material about the work of the court that counsel can use when you're going to be working on these cases and representing these victims. There is so much to do, and although we should have done so yesterday, I think today is certainly a good day to renew our commitment as counsel to do our part to ending impunity for crimes against children. I'm going to stop here and hand it back to you, Heidi. Thank you very much for listening to me.
Well, thank you very much for those remarks. Our next speaker today is Nicole Blumberg. Nikki has been chief of the Child Abuse Unit in the New York County District Attorney's Office since 2014, and she's been serving as a prosecutor for over 20 years. She's investigated and tried a wide variety of murders, police shootings, rapes, robberies, burglaries, and other crimes of violence. She was the acting deputy bureau chief in the sex crimes unit in 2007 and was appointed as deputy bureau chief in the trial division from 2007 to 2013. She has supervised and assisted in the prosecution of adult and child fatalities and hundreds of cases involving sexual and serious physical abuse of teenagers and children. She has lectured nationally and internationally in the field of child abuse. Her international work includes training judges, prosecutors, and police officers on how to investigate and prosecute child abuse cases. In addition to her work at the New York County District Attorney's Office, she was a senior fellow for the Association of Prosecuting Attorneys in 2019. She's also been an adjunct professor of trial advocacy at Cardozo Law School since 2009. So welcome, Nikki, and thank you for being here.
It's a great start. I'm muted. Sorry about that. I should be a little more experienced with Zoom. I figure after all of these 2 years we've all spent doing it this way. Well, thank you so much for inviting me to speak. Thank you to the Victims Committee of the ICCBA to speak alongside this incredibly distinguished panel. It's truly an honor. By way of background, and we're going to do this fairly quickly because you have some incredible people to hear from today. But by way of background, the child abuse unit here at the Manhattan DA's office, we prosecute sexual abuse and severe physical abuse cases, including infant fatalities and some adult fatalities, kidnapping, and child pornography cases. We're incredibly lucky to have a great team here that includes analysts and paralegals and investigators, and I recognize that everyone is not so lucky to have those resources, but it allows us to really do our best to search for the truth, which is so important in these cases, in all kinds of cases, and especially in working with and dealing with children. So in starting off, I thought that it made sense to talk about how the cases come to us and a little bit about our Child Advocacy Center. In an effort to minimize the amount of times that a child has to be interviewed in the first 24 or 48 hours, we have a center, a Child Advocacy Center, as many of you may have experienced, right here in Manhattan, and a number of different agencies that are working together and are all co-located at that center to assist with the child. We have a representative from the DA's office who's fantastic. She actually is on the Zoom right now. In addition to many other groups who are working together, all for the help of the safety of the child and that search for the truth. The interviews that are conducted there are forensic interviews, so it's non-leading, non-suggestive questions that are age appropriate and designed to make sure that the child, we're not suggesting any information to the child about what happened. So the interviews and questions are very open-ended. And many times the children leave and aren't really sure why they are there, because there's some general rapport building in the beginning, which is really important in these interviews that we'll get to in a few minutes. And then just asking them general questions about things that have gone on, and if anything has happened that makes them feel uncomfortable. So in other words, it would never be suggested of, I heard that this happened to you. Let's talk about that. So it's in a much more open-ended way, designed to get that truth, rather than in situations that we're aware of, certainly in children under the age of 10, are more suggestible than adults are. The literature suggests that at the age of 10, children are no more suggestible than adults, but we certainly are utilizing this process of forensic interviews now for children who are under 16 years old, to still try and approach things in the most open-ended way in questioning children, so that we're not suggesting the information to them. So one of the things in this search for the truth to make sure that we are doing is recognizing as prosecutors that these are incredibly serious cases, as are all criminal cases, but there's incredibly serious consequences. Obviously, you just heard in terms of life sentences. there is a lot of jail time in certainly the sexual abuse cases and any kind of serious physical abuse case or child fatality that's associated. Now, whether it's even a conviction that doesn't involve any jail time, that's incredibly serious for somebody who's accused of a crime. And many of these crimes are the worst crimes that somebody could ever be accused of. Some people say that they would rather be accused of murder or be in jail and say that they've been convicted of murder rather than saying that they have been convicted of abusing a child. So of course, our goal as prosecutors is always to get it right. And that is being prepared and spending the time and really speaking to children and making sure that we are doing our best to get it right and that we aren't suggesting a specific answer that we want to hear from that child. So in speaking to children, if you find yourself in a situation that you are speaking to children and don't have that experience, I was asked to just spend a few minutes to talk about some techniques. If you are doing it yourself and don't really have that training, there's no magic formula for doing this. The best advice that I can give is really try your best to see the most age-appropriate questions. Try and find out some background about that individual child, where they're at developmentally, what kinds of, they may have some special needs that you need to be aware of. They may have certain language barriers or issues that you need to be mindful of in speaking to them. You want to make sure that when you're doing the interview, you're in a place that there aren't other people around, that you're not distracted. You're not looking at your cell phone or, a computer screen that's in front of you, that you're alone and making that child feel comfortable. You're going to want to have a witness present with you in all situations, I think, to make that child feel more comfortable and have someone present, who can later potentially discuss any issues. You don't want to find yourself alone in a room with a child, though. Make sure that you're allotting the appropriate amount of time in the beginning. In all of these cases, we tell the people here who are interviewing children, especially when they're starting out and don't have that experience, this is not like other kinds of cases where you can get that information very quickly. You might and likely will need to do a lot of different interviews to get to what the truth is. And you don't want to rush through this because, again, then you're not getting to maybe all of the crimes that were committed. Until that child feels comfortable with you, they're likely not going to tell you all the different things that have happened to them. And it may have been things that they either witnessed or things that they've actually experienced themselves as a victim. So it's really important to allot the appropriate amount of time for these interviews. Make sure you're making eye contact with that child and making that child feel comfortable. We talk about a rapport building that we're doing with that child, where you're talking about things that don't relate to the crime that child witnessed or experienced, and being sensitive to that. Making sure that you're patient, right? So, and let me just take a step back in that rapport building of talking to them about school, what they did that day, maybe what they did over the summer. Get them talking about something that they like to do so they can feel very comfortable with you beforehand. Play a game with them for a few minutes, something that isn't just, hi, nice to meet you, what happened on this date. You're never going to get the information. You're never going to get the truth. And again, you want to make that child feel as comfortable as possible. So that's going to be really important. Going to skip around for the sake of time. So open-ended questions, again, depending upon the age of the child, but really doing your best to ask what happened yesterday is okay, but you don't want to say something like, did you see this happen? Did you see this person hit this person? Did this person hit you with a certain object? Or, in a sexual abuse case, did this person touch this body part of yours? Instead, you want to ask things in a much more open-ended way. Tell me something that happened with your mother, or tell me something that you may have observed last week, last month, and let them take that lead and really try and ask the who, what, when, where, explain. Often a follow-up question is, tell me a little bit more about that. That you'll hear in these kinds of interviews, and something that's good for interviewing children. Be aware that many adults have difficulties, with time and distances and things like that. For every child, it may have been, this happened yesterday. And obviously we've learned that that's not the case, but There are some laws, thankfully, in New York that allow for the time issues that children have, because unless something is associated with a specific special occasion or things of that nature, it's very hard for a child, much more so than an adult, to say, this happened last January, this happened 2 years ago on X specific date. So sometimes you'll be in a position that it's tied to a holiday, tied to their birthday or a parent's birthday, or something along those lines that would allow for more specific dating of events. But beyond that, you're likely going to get a range, and you want to be careful with that. How long something lasted for, that's also something, of course, that adults have trouble with, and you could expect that children would certainly have trouble with the same thing. We were talking, or I was asked to speak a little bit about swearability, and you just heard a little bit about that. In New York, a child is presumed to be swearable when they are 9 years old. So anyone who's younger than 9 certainly can still testify as long as they're competent, but there are some extra steps that need to be taken, right? So when someone is raising their hand and swearing to tell the truth, you have to get to the bottom of, do they understand what it means to make a promise to tell the truth, what it means to swear to tell the truth. So there's different kinds of questions that we ask prior to putting a child in the grand jury, and that can be asked in terms of determining things like that. Do you know what it means to tell a lie? Is that a good thing? Is that a bad thing? Do you know what it means to tell the truth? And you can give them some different kinds of examples. Is it a good thing or a bad thing? Did this happen? Is the sky pink? Is that true? Or is that a lie? Now, I guess depending upon the day, but there's different examples that you can use. And again, different ages that will get you to that determination, which you're going to be making, or a court ultimately could be making, as to whether or not that child is swearable, can actually take an oath and swear to tell the truth. Corroboration is another big area that we focus in on our child abuse cases. And this is an area, obviously, that we could spend an hour talking about, but obviously we want to make sure that we are getting to everybody else. And so I'm going to rush through a couple things to think about in corroboration, and why that's so important, that you don't want to be just in a position that you are putting forth the testimony of a child without having other witnesses that could support and explain why that child is actually credible and is worthy of belief. Many of these crimes occur in private, right? So there's not a lot of witnesses, and the victim is often the only person who can provide those details. And when that's a child, that can be incredibly difficult, because some people won't or don't believe the word of a child, or certainly don't find a child to be as credible as an adult is. So you want to be mindful of that as well, depending upon who's listening and who's judging that testimony of children, and what their own beliefs of children and their credibility is. But things that can corroborate that child are that child's behavior. If there's other witnesses who, maybe it's family members who have observed the changes in that child, talking to teachers, friends, relatives who might be able to explain that that child, you know, was a very happy, outgoing child, and suddenly in this period of time became very introverted. A teacher may say the child no longer volunteered in class, where that child was always the first to raise his or her hand. Friends of that child may talk about significant changes in behavior. You want to get all of that out. They may have had no idea about what the child was experiencing or may have witnessed, but they can talk about those specific changes, which can be helpful. You often see in cases where a child has been victimized, self-harming that occurs. And the child, in many cases, can talk about why that is, but you want to get to the bottom of that through the testimony of other witnesses. People that the child ultimately disclosed what they observed or what they experienced themselves can be incredibly important. We've had many people who have taken the stand and said, I've never seen that child act like that, except when they had a death of a close relative, that child was crying uncontrollably when they were disclosing what the child had actually experienced and the atrocities that were committed. So that can be very compelling testimony to talk about the demeanor, in addition to that disclosure, that child telling what had happened to them. Speaking to the accused, if you have that ability to speak to an accused to find out things that they may be able to help to corroborate about what the victim is saying. The accused will certainly say, oh, I was around that child all the time, but this didn't happen. Or in some situations, surprisingly, we have accused who admit to the crime. They may not admit to the full crime. They may admit, for example, in a sexual abuse case, to touching the child, but not raping the child. Well, of course, that's still incredibly helpful to corroborate that testimony of that child. In physical abuse cases, there can be different objects that were used to abuse that child that are left behind at the crime scene. You want to make sure that you have those that you can use, that you could introduce, but all of those things will corroborate that testimony of that child. Certainly in if you can call doctors or you can call any other kinds of experts, that's always very helpful to talk about. Again, a luxury I know that we have here in New York is to call experts, psychologists at our trials to explain behaviors that are common in sexual abuse cases, to put into context of why, for example, a child would not report a crime like this, especially in a sexual abuse context, right away. It's called a delayed disclosure, or why a child may only talk about part of abuse that's happened to them, but not everything. It's called, a piecemeal disclosure. That's why you want to have a child in for many, many interviews, because that will allow for the truth to come out and what's happened. Social media, computers, things like that, of texting that may have occurred, or contact between the child and the accused is going to be very helpful. And the last thing, again, to talk about, one thing that we wanted to talk about was preparing a child for trial. If you can show that child where they're going to be testifying, we actually bring our children into a courtroom tour and take them and let them sit in the seat that they're going to be testifying in. That's incredibly helpful. Going over the questions with that child beforehand so that they're not surprised. Giving them an example of what a cross-examination may look like. So you're actually doing some sort of mock cross-examination and really reviewing the topics with them and everything that they've told you in the past, so that things aren't, so we can minimize as many surprises as possible. Being aware, I talked about this a little bit before, but language, making sure there are children who don't know what before and after means. So if you're asking that question, you want to make sure that they know the difference between before and after. Instead of asking that and putting them in a position that they have to ask you questions or say that they don't understand or answering the question incorrectly. So those are, in the amount of time, obviously, that we have. I wanted to go through some broad topics that I was asked by the committee to cover. I hope that goes over it in broad strokes for you. But the main thing is not to fear children. They do give a lot of valuable information, and it's important to really just listen to what they have to say and do your best to not lead them through it and hear it from them rather than providing them the information.
Well, thank you, Nikki. That was incredibly helpful, and thank you for sharing your experience and expertise on this. I hope that we do have some time to come back to some of these topics during the question and answer as well. Our next speaker is Priscilla Aling, and she will be addressing this, representing child victims, particularly at the ICC and in the early stages of the proceedings and investigations. Priscilla is a lawyer from Uganda, working as a field-based member of the Legal Representatives for Victims, the LRVs, in the trial of the prosecutor versus Dominic Ongwen before the ICC. She coordinates field-based consultations, investigations, and documentation of victimization, views, and concerns of a staggering number of 2,605 victims participating in this trial. Priscilla is also a director for the Victim Support Initiative, a nonprofit affiliate with the LRVs, whose goal is to enhance victim participation in the Ongwen trial and promote victims' rights in transitional justice processes in Uganda's domestic courts in domestic cases as well. So Priscilla, welcome.
Thank you, Heidi, for that introduction, and thank you everyone who's joining us today. Uh, it's interesting that Heidi mentioned the number of victims that we represent. It's very important because out of the 2,605 that we represent, 32 of them currently are child victims. The number was much bigger. We had a couple of hundred at the beginning of the trial in 2006, but with every year that goes by, we have had more of them become adults. So I believe this will be the final year will have child victims, um, child victims who were present during the attacks when it happened in 2003 and 2004 in the communities of Abok, Odek, and Lukodi. These are villages, rural areas in northern Uganda. I say this because I think the previous speaker shared some tips that I was making note of it, and the circumstances are very different from the ones that we have. And so, uh, to talk about some of the main, I will talk about three main points that we encountered during the investigation periods and consultations. And one very important one is the fact that the trial started over 10 years from the events that occurred. As I mentioned, 2003 and 2004. So when we started investigations, that was in 2016, over a decade had passed, and of course there are questions about what might the child might recall, or if they were present and all that, but you have to make consideration for. So the first mistake, which was also a lesson at the same time, is making assumptions about what the child victim may or may not know about the crimes that occurred. So I'll give two examples about this. On one side, we had one of the major challenges that children born in captivity, born sexual slavery and rape, is stigma. Once they return home, they're stigmatized by the community because of the circumstances of their birth. And in many cases, some families opt to protect these children from the stigma. They decide they choose to hide the circumstance of this child's birth. So there are instances where in the child's application form, it's clear that this is a child born in captivity. But when you sit down to interview the child, this is not there. The child might not know about this. So then if you haven't had the opportunity to engage with the parents or the caretaker prior to the interview that you're going to have, you risk exposing something that the child did not know about. And of course, there will be so much damage about this because many of them have people that they believe are their parents when indeed they are not their parents. So that is one thing about an example of making assumptions. And then the other one that I've never forgotten was myself and my former colleague Sharon, thought to interview a child. They had come with their parent, and we thought, let us try to interview them and see what they can speak about regarding, the harm that they might have gone through. So because this child was really young, we did not expect that they would speak so much about the harm that occurred. So the first question we asked was, what's your mother's name and your father's name, just like what the previous speaker was talking about. And then the child says, my mother died. She was killed, and with my little brother who was pounded to death and all this. And I recall that the first feeling that I had was panic because I did not, expect this, and I felt like I had, caused so much damage to this child, and I had no prior training. I think the earlier speaker talked about it. There's no sort of the court does not provide this for external teams. I don't know about the other teams, but we had talked about providing, counseling services, and we as a team don't receive this. So we cannot even provide that. So we didn't have any prior training on how to address this. And it has remained one of those experiences that haunt me. And, I carry that guilt because of that lack of preparation and assuming that such a young child may not know what happened. So it's very important to have that engagement. And The other thing that I would like to also share about is the creating, appropriate spaces for children for meetings. Um, Earlier in our engagement, we noticed, because our engagements are usually large meetings of 10 or even more people. So we noticed that some parents would bring children out of school so that they can attend the meetings when they're supposed to be at school at the time. So when we realized that we learned to design the meetings during the holiday period so that we do not affect the studies of the children, and then also tailoring the questions, uh, so that it's appropriate for the children. Because then there are some things that are discussed with the rest of the communities, with the elders, but there are some things that children may not be able to understand, although culturally in northern Uganda, um, the harm that occurred is discussed candidly, but it's still our duty, I believe, for us to make sure that we tailor it in a way that a child can understand and does not cause any other further trauma. Um, and then the last thing that I'll speak about, and then I'll allow Joseph to add on to that, is the sensitiveness surrounding children. And that is in relation to you who is working with the children, who is representing the children. So we received so many accounts about what happened. We have had people who have, rape experiences. We have had, about torture and all that. But in most cases, the effect of it, the impact of it is harder on you who is receiving this information if it's coming from a child, or if the experiences are, that the experiences are that of a child. So there's usually so many feelings, the pain goes deeper, the guilt that you feel. One thing that is common with people who represent victims, so people who engage with victims directly, is feeling the guilt. We have been told in therapy is that the guilt you feel is a lot harder when you're dealing with children. So we have constantly struggled, had this battle of the need to do something, and you feel like you have failed if you don't do something. So if you meet a child who is out of school because of, they don't have tuition, you have this need to want to fix it. If there's a child who has a medical condition, you have the need, you feel like I could pay for this child's medical condition, which is something that is doable, but it's not sustainable. If you're dealing with 2,600 people, it is not sustainable. So it's important to have self-care, to constantly debrief and think about, your actions. Do not act on impulse, and always. I think one way that we found a way to address this was, coming up with BSI as another way that an institution, not an individual, can try to address some of the problems that are there that are not exactly within our mandate or within our capacity. So those are the three major things that I'd like to share for now. If there are any others, I'll share during the question and answer period. Thank you.
Thank you so much, Priscilla. I think it's so important to address the trauma and making sure that we're not re-traumatizing child victims. So thank you very much for addressing those topics. Our next speaker is Joseph Manoba. He will be addressing this issue, particularly from the aspect of the role of counsel at the ICC and during proceedings. So Joseph is a Ugandan lawyer and currently serves as counsel on the legal team representing victims, also in the Onwin case before the ICC. He is a member of the ICC Bar Association, East African Law Society, and Uganda Law Society. He is a Queen's University Belfast LLM Human Rights Stephen Livingston Scholar. He holds a postgraduate diploma in legal practice from the Law Development Center Kampala and the Law Development Center, and a bachelor's of law degree from Makerere University, Kampala. Joseph has worked with the Victim Participation Reparations section, the PRS, of the ICC as a visiting professional. He is a founder of the Uganda Victims' Rights Working Group and now Uganda Victims Foundation. He has also previously served as coordinator of the Uganda Coalition for the International Criminal Court. Prior to his appointment as legal representative for victims in the Ongwen case, Joseph practiced criminal law in Uganda. So welcome, Joseph.
Thank you, Heidi, for the invitation. And I'm honored to speak today at this meeting. Obviously, there are lots of experiences from different people attending this Zoom meeting. But hopefully, I can share some experiences from the Dominic Ongwen trial. Allow me, obviously, to start with the basics. We all know victim is defined under the rules of the court, and the child falls squarely within the definition of a victim under the rules. Obviously, the crimes that fall within the jurisdiction of the court, again, are those crimes that any child could be a victim of any of those crimes. In the Dominic Ongwen case, of course, we are talking about crimes against humanity and war crimes. Dominic Ongwen, as you probably know, and was charged with, amongst others, sexual and gender-based crimes, including forced marriage, torture, rape, sexual slavery, enslavement, forced pregnancy, outrages against personal dignity. Why this is important, why I'm outlining this, is that most of the children, or most of his so-called wives, were abducted as little girls and held against their will in his household as ting-tings, and later forced to be his wives and forced to, bear his children. He was, Dominic Ongwen was also charged with the crime of conscripting children under the age of 15. We all know now from the case that most of the LRA fighters were abducted as young boys, still attending primary school and forced to participate in hostilities. Now, many of these children, as Priscilla has indicated, some have, become adults as we speak today, while there are others that were victimized and did not necessarily get abducted or end up as a forced wife, but suffered some form of victimization in their own right. Now, obviously, victims are allowed to participate in the proceedings. Again, this is basic in terms of the ICC, we all know. So any child, any victim who is a child could potentially apply to participate in the proceedings of the court against an accused person. In this case, we're talking about Dominic Ongwen. The pretrial chamber in the Dominic Ongwen case, when it issued its decision on participation, I wish to quote the extent of participatory rights that were granted to victims, which of course includes child victims. The chamber there said that the legal representatives shall have the general right to consult the record of the case, including decisions of the chamber, submission of the parties and participants and the registrar, transcripts and evidence disclosed by the parties and communicated to the chamber, and shall receive notification of documents filed. This right shall extend to public as well as confidential documents or evidence in the record of the case. Notification of documents or access to evidence communicated to the chamber shall only be withheld from the legal representatives of victims if there are specific reasons warranting this measure. The chamber also said documents filed in the record of the case which cannot be notified to the legal representatives of the victims must be marked confidential, prosecutor and defense, or more restrictively if appropriate. So by this decision of the chamber, we as legal representatives, we had our kind of participation rights cut out for us. And of course, representing victims, including children, then we were allowed to communicate views and concerns expressed by children within the context of this decision by the Pretrial Chamber. We were able to engage, of course, children, as Priscilla has stated. One of the things that we did to kind of put this in effect was that we undertook outreaches and awareness sessions. One, to explain what war crimes and crimes against humanity, obviously, as you can imagine, these are things that, or something that it would be difficult for any person, let alone a child, to appreciate. But we did undertake outreaches and awareness sessions to kind of break down the message for these children, since they were participants in the case, so that they have an appreciation and understanding of the kind of trial that Dominic Ongwen was facing. Of course, in these sessions, we explained the charges that were preferred against Dominic Ongwen, the trial processes, including the various interlocutory appeals and applications filed by the defense. And of course, we also explained the rights of victims in the proceedings. We also undertook consultations and instructions from victims, including one of the things that the Pretrial Chamber required us to do in the very beginning was to kind of consult with the victims about their anonymity in the proceedings. It was important because at the time, the trial process was just beginning, and obviously victims that we represent were concerned that perhaps their identities would be disclosed to the defense, which would cause maybe fear in them or potential retaliatory attacks. And so we did consult from our clients, including children, and they did indicate to us that they would prefer that their identity remains anonymous. The other things that we have done in terms of the activities, we have tried to document the harm suffered, including amongst the children themselves. We have tried to, in these other activities, we have tried to identify potential victims for the case in terms of, the minor investigations that we are allowed to undertake to kind of have or listen to the stories of these victims and see if we can identify potential witnesses to present on behalf of the victims. We have spoken to journalists, we have spoken to researchers, and we have attended various number of stakeholder engagements and spoken about the victims that we represent, including child soldiers. Now, one of the things that I should speak about is obviously Rule 81 of the rules provides for general stipulations on the restrictions on disclosure of confidential information. And the nature of the Dominic Ongwen case was that it was it dealt with confidential stuff all around it. Children, of course, needed. The chamber allowed us in its decision allowed us to communicate confidential information arising from the case, but also required us to take note of what confidential information we were communicating, so that it is managed and controlled, and therefore as part of this process we were required to maintain confidentiality of the information that we received, obviously from the parties and participants, but also that from the information that we were gathering or working with in terms of the child victims that we were representing. So confidentiality is very key. As an LRV representing children, you have to maintain that. I will speak about this later because we, as one of the challenges, their confidentiality may become an issue for an LRV in certain situations. So it's important that we keep mind of this. Obviously, as part of the confidentiality process, victims require protection measures, especially on account of their testimony. As you know, many of the children that were abducted and recruited into the LRA ranks were forced to commit atrocities, and therefore, when it comes to their testimony in court, it is very important that confidentiality about them is maintained. So these are some of the things that we did. I want to note the advantages that accrue, as it may be, to representing child victims. One of the things that I would highlight here is that the representing children helps them to enhance their knowledge, primarily because this is a trial that was taking place in The Hague, not in Uganda. It's an international criminal court trial. So it was important that as we speak to victims, but more specifically to child victims, we had to kind of build their knowledge why this case needed to take place, and try and explain the processes of the trial. We definitely explained or helped them to enhance their knowledge about victim participation in the ICC proceedings. Obviously, then you think about meaningful and effective participation. As an LRV team, you give the children the opportunity to tell their stories, and in telling their stories, victims may disclose, like in our case. I'll give you an example. For the first time, what happened to them. There are many of these former child soldiers, former children who have grown up into adults who have never spoken to anybody in terms of their experiences. One of this example is a victim I'll call Zed, who was a child. He was abducted from his home in the camp when it was attacked, and along the way to the bush, he was forced to participate in beating another victim, a girl who was his next door neighbor at home. He was forced to sexually abuse the body of this girl after she had been killed. And the perpetrators, of course, were laughing at him during the sexual incident. So speaking about or giving this child an opportunity to speak their experiences in a way kind of helped this child to speak for the first time. Probably he was not a child anymore, but he was a young adult at the time. But his experience as a child, he needed somebody to, listen to him and listen to his experiences. The same thing happens for another individual that I'll probably, because of time, I will not get into. But having said that, let me then talk about the challenges we have encountered representing child victims. One of the challenges, and Priscilla did touch on this a little bit, most or some of the children were suffering from trauma or even potentially PTSD from the violence they experienced. And at the time when we, got out to do these engagements with the victims, we were ill-equipped to deal with these kind of challenges. Priscilla did mention the example of this child that her and Sharon spoke to, and this child, for some reason, was hell-bent on speaking her experiences. And as Priscilla mentioned, they did, we were not, as I said, we were ill-equipped because the Victims and Witnesses Unit of the court had indicated to us that they were not in a position to assist us or support us with a psychologist to come around along with us to the field, so that in situations like for this child, then they would be able to speak to the child. But because we were doing this in groups, when they encountered this, they kind of suspended the meeting and consulted with me, and I offered to speak to the child. And when I did speak with the child, I also determined that perhaps it was not helpful for the child to continue narrating her story, because she had witnessed very gross events surrounding her mother and her little brother. And I thought at the time that allowing her to continue to narrate the story would probably damage her completely. So we terminated. She was a potentially good witness for the victim's case, but because of the experience and the fear that she would probably be extensively traumatized, we suspended or terminated the interview with her, and did explain to her that it wouldn't be helpful for her to continue narrating the story of her experiences, but perhaps in the future, if there was an opportunity, we would still go back to her and see how we could best speak to her. Another challenge that we encountered is that, of course, some children were not forthcoming with their stories or accounts of their experiences in terms of the chronological events about the things that happened during the attack. And obviously it is understandable because due to lapse of time, as Priscilla mentioned, 10 to 15 years is such a long time. Most of these children were toddlers at the time the camp was attacked, and their impression of the events during the attack may have been captured in their mind, but most likely they may not have been in a position to remember all the detail of the events compared to those who were a little bit older than them, such as those who were abducted. And so one of the fears that I personally had was that because the conflict and the violence in northern Uganda has been discussed generally, I thought that these children's minds or thoughts about the violence may have been shaped by what they had. And therefore, and it was easy to tell because as we spoke to these children, of course, using open-ended questions, you would see that the flow in terms of the narration was hindered, and we couldn't place it whether because the child couldn't remember or because of their own experiences. It was difficult really for us to kind of tell what was hindering the proper narration of their accounts. Some children, of course, we discovered were experiencing nightmares and reported to us seeing spiritual creatures in the night. Once again, we did not have any practical solutions to these kind of challenges. but we did kind of speak to them and try to encourage them to, talk to other people and maybe their parents about these experiences to help them, overcome these challenges, because as I've said, we were not prepared for these kind of things. Again, like Priscilla did indicate, most children were basically destitute and in need of support. As LRVs, we struggled with this because we were limited in what we could do, but we did try to empathize with the children, but we also engaged with the Trust Fund for Victims in the field office and also through their implementing partners to kind of assess what kind of assistance programs the Trust Fund was undertaking in the communities, and encouraged, of course, these Trust Fund partners to go out into the same communities and try to see if they could be of any assistance to the children and of course the rest of the victims. The other challenge that I would share is that the prosecution, and this is in terms of what I said earlier about confidentiality, the prosecution usually, or in the Dominic Ongwen case, used prior recorded statements. And as LRVs, we had assured our clients that they would remain anonymous, their identities would not be disclosed. However, in the course of the trial, some of the witnesses, prosecution witnesses, had not disclosed all their relations to the in their witness statements, or in the course of the trial itself, in their testimonies, did not disclose the certain relations. And so when other witnesses who were called, spoke about the relations of that kind of the former witness testifying, then it happened that some of the witnesses who were dual status individuals that we represented had their names being disclosed to the defense, and yet we had assured these victims that they would remain anonymous. So it was a big challenge for us, because again, that meant that our assurances were not truthful to the victims, and we were forced to come back to the communities to kind of try and explain these happenings. Obviously, this was not a making by the LRVs, but I think this happens with the prosecution because as they do these prior recorded testimony statements with their own witnesses during their investigations, then it's either the witnesses don't disclose fully their relations, and unfortunately for those clients, the dual status individuals that we represent ended up having their identities and other information disclosed to the defense. Fortunately, nothing has happened out of that disclosure, but it is something that we had to contend with at the time. The other challenge that I would also mention.
I'm so sorry to interrupt you. I think we have about a minute left, and we do need to move on to the next speaker so that we do have some time for question and answer. So if you could maybe spend about 30 seconds, a minute with your last remarks, that would be great. So sorry to stop you.
Thank you. I could share tips and best practices that could be of help. One of the things that I would say then in terms of tips and best practices is that the prosecution again has the duty to disclose to the defense anything that comes to it. As an LRV representing a child, one needs to be careful. Anything that you share with the prosecution would potentially be disclosed to the defense. We had an experience where we thought that the prosecution would investigate, but the prosecution let us know that they were going to disclose this, which was unfortunate because, again, we were dealing with a victim who was not prepared for that disclosure. We also engaged, it is important also to work with professionals, experts. We did engage a team of experts who kind of went to the communities and spoke to children amongst the victims that we represent so that they could, get a whole picture of the experiences of victims. I will leave it at that. Thank you very much for listening.
Well, thank you so much, Joseph. And I think it's clear from everything that you've shared about your experiences, about the challenges that you face, and the suggestions that you've given, that there's so much to talk about on this topic, and that I think this needs to be a continuing conversation for all of us who are practicing before the International Criminal Court. Our last speaker will be addressing this issue from the perspective of the bench, which I think all of us can benefit from knowing about how judges approach this topic as we ourselves are practicing before the court. Tusara Rajak Singh is our next speaker. Tusara is currently a judge of the High Court of the Fiji Islands. He has served in this position since November 2014. Prior to this position, he served as Master of the High Court in the Civil Division from August 2013 to October 2014, and was resident magistrate from November 2009 to August 2013. Tusara has also acted as referee at the Land Transport Appeal Tribunal from January 2010 to August 2013. He was the additional district judge and magistrate in Sri Lanka from October 2004 to November 2009. And he is also a member of the ICC's Victims Committee, which organized this program today. So welcome to Tusara, and we welcome your remarks. You're just on mute.
Thank you, Heidi. I hope everyone can hear me now. Okay, dear friends, I'm pleased and humbled to be part of this experienced and knowledgeable panel of experts. I must first express my sincere gratitude for the Victim Committee for organizing this timely webinar on this crucial topic of child victims and witnesses in court proceedings. We have all heard the very interesting views of the bar. Now let me share with you my experience and my views as a trial judge with dealing with child victims and witnesses. Domestic and international courts usually receive children as witnesses in proceedings. Obtaining evidence of children is based on two materially important principles. The first principle is to provide the child victim or the witness with an opportunity to give his best evidence. Second is to protect the child witness from secondary victimization. These two principles are based on the rights of the child to express his view, opinion, and belief freely, and the right of the child to be heard. Accordingly, the judge has to provide the child witness with an opportunity to enjoy these rights effectively. The child must be an informed participant and treated with dignity and without discrimination in the proceedings. I do not wish to elaborate further on the scope and the legal definition of these rights of child, which I no doubt believe that you all are well versed in. Let me now focus on how the judge facilitates the child to exercise these rights effectively in the court proceedings. The paramount duty of the judge is to provide the accused with a fair trial. It is a process to convict the guilty and acquit the innocent. This process consists of two main steps: the process of obtaining evidence and the process of decision making. This process of obtaining evidence has two main components: the pre-trial stage and the trial stage. During the pre-trial stage and the trial stage, the judge has a duty to harmonize two significantly competing interests. On the one hand, the rights of the child, and on the other hand, not to compromise the accused's cardinal right to have a fair trial. The free trial stage is essential to properly demarcate the scope of the trial and the role of the parties, including the child witnesses. In Fiji, a new Criminal Procedure Act enacted in 2010 introduced a comprehensive free trial procedure regime, identified the trialable issues and agreed facts, would surely assist the parties in correctly understanding the scope of the evidence that the child witness is required to give, that enable the parties to adequately inform the child of his role in the proceedings and arrange the court facilities to meet his special needs. I can confirm with my own experience that the free trial procedures are extremely helpful. I had a rape trial involving a 14-year-old female victim with special needs 2 weeks ago. The free trial procedures allowed me to properly understand the special needs and the requirements of the child witness to give her best evidence. Another rape trial, which I presided over, involved a child witness of 3 years old. The pretrial hearing allowed me to understand the special needs of this young witness, such as her meal plans, resting and napping times, and play times, etc. Accordingly, the court was able to schedule the trial time frame so as not to disturb her usual daily routine, making her feel easy and, more importantly, safe at the hearing. She initially gave evidence from the special child witness room via video link. 2 days later, she felt uneasy in the special witness room. Then we had to have the hearing in a very informal court setting where both the lawyers and I participated without the traditional court attire. I sat on one of the benches allocated for the public while she gave evidence walking around the courtroom. I can state that the pre-trial stage focuses much on the rights of the child witnesses than the accused rights. It is because that period would be used to empower the child witness to provide his or her best evidence. However, the overarching focus during the trial process shifts to provide the accused with a fair trial. The trial judge cannot compromise the right of the accused to have a fair trial with the right of the child witness. I now take your attention to the process of receiving the evidence. Usually, evidence needs to overcome two main hurdles to be considered truthful evidence. The first is admissibility, the second is the credibility. When it comes to the admissibility of the evidence, it is the best practice to receive the evidence of a child witnesses based on the presumption that every child is a capable witness, irrespective of his or her age. The child's age must not be the sole determinator to determine his or her competency as a witness. Let us briefly examine the approaches adopted in few common law countries and the ICC in receiving evidence of child witnesses. As you know, the Rome Statute says any person is allowed to give evidence upon taking the solemn undertaking as expounded under Rule 66. However, if the court finds a person
Tushar, are you there? I think his video might have stalled. Oh, yes, I think you're back.
Can you hear me now?
Yes, thank you.
Yeah. If the court finds a person under the age of 18 does not understand the nature of a solemn undertaking, the court may allow the person to testify without this solemn undertaking if the court is satisfied of two things, which are the person can describe matters of which he or she has knowledge of, and that the person understands the meaning of the duty to speak the truth. Therefore, the ICC approach to the competency of the witness is based on the witness' ability to comprehend the responsibility of telling the truth sufficiently. The Youth Justice and Evidence Act of UK considers the issue of competency separate from the questions of sworn and unsworn evidence. Accordingly, if a person understands questions put to him and gives answers to them which can be understood, he is a competent witness irrespective of his age. This approach is different to the ICC approach. Fiji has somewhat of a hybrid approach. Section 10 of the Juveniles Act allows the court to have unsworn evidence of a child of tender years if the court finds he does not understand the nature of the oath. It is further required that the court be satisfied before taking the unsworn evidence that the child possess sufficient intelligence to justify the reception of his or her evidence and to understand the duty of speaking the truth. This is more similar to the ICC approach. However, the general provision concerning all other witnesses, including children who do not fall under Section 10 of the Juveniles Act, and young adolescents between the age of 12 and 18 is found in Section 117 of the Criminal Procedure Act, where it states that every witness must be examined upon oath or affirmations. However, Section 117, subsection 2 of the Criminal Procedure Act has allowed the court to obtain unsworn evidence based on the witness's religious belief or immature age. Accordingly, the Fiji law allows unsworn evidence based on the maturity of age or religious belief. There is no requirement to satisfy the competency of such a witness before allowing unsworn evidence. I take you to the New Zealand law. Section 77 of the Evidence Act of New Zealand does not require a child under the age of 12 years to give sworn evidence. It is only needed for the judge to inform the child of the importance of telling the truth and not telling lies, and make him or her promise to tell the truth before giving evidence. Therefore, it appears that the approaches of UK, New Zealand, and Fiji to some extent are more liberal and provide more comprehensive space for the child to constructively and effectively participate in the proceedings. Coming to my conclusion, let me take you to the process of determining the credibility of the evidence of child witnesses. Dealing with child victims and witnesses are very sensitive, delicate, and challenging process in the court process. I'm not going to discuss the legal approaches in deciding the credibility. Still, an essential aspect of fairness, that is the judge's inner impartiality in assessing the child witnesses' credibility. We all know judges are also human, are not immune from their own prejudices, views, and perceptions when dealing with child victims and witnesses. If you define bias and partiality as total absence of preconceptions in the minds of the judges, then no one has ever had a fair trial and no one ever will. The judge's duty is not to determine the moral culpability, but legal culpability. Therefore, it is one of the paramount responsibilities of the judge to properly comprehend his own prejudices, perceptions, and views and leave them aside in his decision-making process of the child witnesses. This wisdom of the judicial mind allows the judge in conduct the trial, giving the accused his right to have a fair trial while properly recognizing the rights of the child victims and the witnesses. So let me conclude by stating that we as lawyers and judges during the court process must make the child feel that we are not a part of their problem, but are the solution. Thank you.
Thank you so much for that insight and for your remarks. So we are now at the point where we would do a question and answer. I note that we are at 90 minutes, which we had intended for this program, but we would like to go a bit longer. And if our speakers could indulge us with a few extra minutes, that would be most appreciated. And I hope that everyone here can, of course, if you can't, the recording of this event will be on the ICCBA's website and also the YouTube link that was sent around before. So For the question and answers, we ask that, or welcome everyone to turn on their cameras at this point if you'd like to. I think this would make it much more of a discussion with everyone. For asking a question, you're welcome to ask a question live yourself. If you could please raise your hand on Zoom using the reaction button at the bottom of your screen and then clicking raise hand, and then I'll call on you to ask that question. Or if you prefer, you can put your question in the chat if that's better, and I can communicate it to the speakers. One note, please keep your questions to questions and not as much to remarks, because we do want to make sure that in the 15 minutes we have left that our speakers are able to fully answer those questions for everyone here. Last note is that I have seen that some people have put some materials in the chat. So if anyone is interested in that, please go ahead and take a look at those materials before this Zoom ends, as we won't have access to it after that. So if everyone would like to put their videos on now, and please let me know, raise your hand or put something in the chat for any questions. I see the first question coming from Brian Kennedy, who is also a member of the Victims Committee. Brian, if you want to unmute and ask your question.
Sure. So thank you all the panelists. It was great presentations. So I had a couple questions, but I'm going to keep it to one. And the question is for Shaimala, if you're still on. All right. So Shaimala was talking about getting cases in front of the ICC. So my question is, what is the best way, do you think, to conduct outreach to child victims in order to organize an Article 15 submission to the Office of the Prosecutor for the International Criminal Court? So it's about outreach.
Thank you so much, Brian, for that question. But I'm going to actually pass the question to either Joseph or Priscilla, who are really the experts who have done this before. And I'm also looking forward to learn from them what the approach would be. If you don't mind, Joseph and Priscilla, I'm sorry for this.
Thank you, Shamala. Well, my response is that in our experience, we have, and Priscilla did mention some of this, we organized specific sessions for children where we engaged the children and spoke to them, about the activities of the court, about the developments of the court in the courtroom, and also kind of fielded their questions. So in precise terms, we had separate sessions for children from the adult sessions. Thank you.
Joseph, how did you find the children, or how did the children find you? What kind of outreach do you do to introduce them to the court?
Thank you, Brian, once again. Well, basically, we have intermediaries in the communities, and these intermediaries help us to mobilize the children. So basically, we send out information having identified who is a child within the group of victims, and we communicate to the intermediaries and say, please organize for us a meeting with these specific individuals. And they simply get for us those individuals, and then we have sessions with them.
And if I may add something real quick on that. So at the time of the beginning of the trial, the VPRS section of the court did some registration of victims, and that's how we got the 2,600 that we mentioned earlier. And we were presented with a database of these people with the names, date of birth, and their locations. So what we have been doing is building on that using the intermediaries, and we have gone a long way to identify a lot more than the initial number, but that database, the initial database that we had, is what has been very helpful for continuing to engage with this number. Thank you.
Thank you, Priscilla. We had one question that came in on the chat that I want to communicate. It says, how do lawyers deal with secondary PTSD for themselves? What preventative and curative measures can be taken? Does anyone in particular want to address that issue? I know, Priscilla, you had mentioned self-care in your remarks. And Nicole, why don't you go ahead and start?
Sure. So it's something that definitely comes up here a lot of vicarious trauma or secondary trauma from hearing the worst of the worst, right? The stories that everybody's hearing and experiencing. I would say that really talking to other people, if there is somebody who's available, really being able to, it's hard to keep it all inside. Some people have different, exercise, things like that, just some other way or an outlet to deal with the stress, and really making sure that you're taking vacations and taking care of yourself, something that you really enjoy doing. For some people, it's cooking, something that's therapeutic for them, but that gets out of hearing all of this. And it's hard, certainly to not take home with you. But unfortunately it does. And it takes a toll. It certainly does. And I think anyone who does this work and is listening to these stories all day long will certainly say that. I like to joke that I'm dead inside. I'm really not, but I think you have to find a way to compartmentalize so that it doesn't take over. That's how I would answer that.
Any other panelists want to? Shama.
Hi, can I just suggest that there is a very useful resource that was created by UNITAD, which was the Trauma-Informed Field Guide. And that probably is very relevant to us because it involves international investigations. And there is a chapter included there on self-care, which can be a good resource. And also, can I just add, when I have the mic, is that in some jurisdictions, there are also cultural unawareness or inhibitions to addressing, I think, the trauma that professionals feel. And sometimes in those settings, what can be very helpful is if there was mandatory requirements for anyone and everyone dealing with these kinds of cases to have some kind of counseling or other support related or anything else related to supporting such professionals.
Can I?
Yeah, sure.
Yes, please. Joseph, if you have something to say.
Well, in the ICC experience, you probably don't know as external lawyers, you don't have any support from the court. That's one of the major undoing factors of representing, victims generally at the ICC. But as a team, one of the things we kind of had to, do is basically debrief amongst ourselves and speak about the stories that we had encountered and try to, talk about them. And, this is how we simply kind of dealt with the situation. But with the ICC being an external team, you have no help in dealing with this kind of thing. In fact, members of the team have broken down a couple of times, and you're on your own.
Thank you. I think we'll move to the next question. Alexandra, I see that your hand is up if you'd like to ask your question.
Thank you. And thank you so much to the panelists. I was wondering how you handle either guardians or parents who don't want you to speak privately with their children or to speak with their children at all, or at some point during the process decide that they don't want their child to continue on with the case, particularly at the ICC, where these processes are incredibly long. So I was just curious how that's handled, if there are support for the families in addition to the child victims.
Is there anyone in particular you'd like to ask that question of, or?
No, that's open to anyone.
Any of the speakers want to address that?
I, Mr. Majid Hussain Shah, wants to ask a question from the last speaker, that what could be the mode of checking the competence of a witness if the victim child is less than the age of 5 years?
Thank you for that question as well. On that note, why don't we take one more question as well from Diana at the same time, and then we can have the speakers address any of the 3 questions that were asked. Diana, if you want to ask your question.
Hello, my name is Diana Constantinivi. I'm a barrister at 33 Bedford Road Chambers in London. Thank you all the panelists for this wonderful topic. And I don't have any experience whatsoever when it comes into representation of children before International Criminal Court. So this has been very helpful. I'm just interested to find out from any of the panelists. I've heard about trauma, and trauma is a very subjective term that can be stretched and shaped depending on the circumstances of each child. So how far can this trauma be applied on the principle of Dowling-Cabox? And if I may remind that where a child is deemed to be not capable to form intention to commit a crime. So we know that on the ground, sometimes children, they are caught to commit crimes themselves. So this kind of evidence that there may be self-incriminatory, how far is this principle stretched? And how do you deal in cases like that? Because we do know that sometimes even the perpetrators and the defendants that they do come before court, they may have themselves experienced something similar, and they become, so it can go both ways. So I'm just interested, how do you deal with this delicate balance? And I do appreciate maybe a very peculiar, the minority of your cases. But I'm just aware that there are cases in criminal courts and international institutions that they may be dealing with this matter. Thank you.
Would any of the panelists like to go ahead and address one of those 3 questions?
Heidi, I could speak on the first, and then someone else mentioned that. So I don't remember who asked the question, but it had to do with how to handle, parents and caretakers who might not be willing to let us have the engagement with the children. In our case, I think I mentioned this earlier, but it's very important to build a relationship with the parent. So this is not going to happen on, the first instance, but it's going to be a continuous engagement, because once they trust you, then they can understand, they can trust you with their children. And so to some extent, we have been lucky that some of the parents and caretakers are also our clients. But in situations where they are not our clients, for instance, some of them are represented by the OPCV and the ICC, we have, in cases, talked to their representative about this concern that they may have. We have had some meetings with the parents and caretakers to explain to them what the purpose of the meeting is. And in case we are having engagements that are not very sensitive, we have had them be present at the time we are engaging with the children. So you'll notice that when the parent insists on attending the first or second couple of times, they will later on, relinquish that power and, allow you to interview the child without them being present. So it's really about building rapport over time, in my experience. Thank you.
Thank you, Priscilla. Nicole, I'm going to call on you because we had a question from the chat that is it's similar to Alexandra's, which asks specifically if you have any tips, experience, remarks regarding the work with parents, legal guardians of children being interviewed, particularly in regards to consent consultations needed with them, influence suggestibility. If you could address that along with Alexandra's question. That
Sure. So what we do is we meet with the parents before we're meeting with the child and explain the reasons why we need to meet with the child alone. If the child may not disclose certain information, because the parents are present or anyone else is present for the interview. So it's something I should have stressed even more when I was speaking, because that's a really important thing to do, is making sure that in addition to the other things that you're really alone with that child. Usually when explaining that to the parents, that there's certain things that they won't say or will be influenced by in front of the parents, we're successful. There are situations in which we're not, and we can't convince the parents to go forward. We also videotape all of our forensic interviews, and that's something that at times a parent may not consent to, but when we go through that explanation, in the vast majority of cases, we are successful. In terms of parents who along the way are upset with the process and don't want their child to continue, again, what we do is we and are lucky to have the resources to provide the counseling and ability to speak to the parents as well, to explain why the delays, why it's so important that the child is still involved. We do have the power to subpoena the child, but we really don't want to do that. We use that more sparingly. If there's a reason, certainly if the child has mental health issues that are really affected by testifying, there are situations in which we would not proceed in a case. But other than that, depending upon the conduct that occurred, doing our best to work with counselors and convince the parents that that's what's necessary to keep that child safe, or the consequences if we don't proceed and what's going to happen with that case. But they're great questions and they're tough issues.
Sorry, is this something that you have addressed from the perspective of judges as well?
Yes, to the issue of the witnesses under the age of 5. So we had to approach every child witnesses as a capable witness. We had to understand that every human has the ability of feeling and forming their views and communicate them. The children usually communicate their own sounds and on their own ways. So in that case, we can get the assistance of some specialist to translate or communicate their views to the court. Just because of the communications barrier, we can't completely shut them away from the court process. And the issue of the unhelpful parents is a very big issue in Fiji, where in the traditional community, there's a practice of formal apologies. So the parents are very much concerned and happy with making a formal apology, accepting the formal apology within the community level and forget the issue. So in that case, they are very reluctant to send their children, especially the sexual offense, in respect of the sexual offenses. So that is something that we are dealing with at the moment. And it needs a lot of education in the community level to make sure the sexual offenses are not something that you can just forget and apologize and settle. It should go to the court process and punish the offenders appropriately.
Thank you. I do want to give the speakers an opportunity to answer Diana's question if they have any thoughts. Is there anyone that would like to address that? Maybe Joseph, Shamla, do you have any thoughts on that question?
Yeah. In the Ongwen case, we haven't had any experience with children below the age of 5. So we can't say much about representing such individuals. But I think what has helped us in terms of representing children generally has been that from the onset we have tried to work with children by communicating to them in the general kind of awareness sessions where everybody, including the adults, are present, but also holding exclusive meetings for the children. And like Priscilla says, we have been fortunate in the sense that parents have been participants themselves as victim participants in the case. So perhaps our situation might have been made much simpler than a situation where you do not have parents participating as victims in the case. Thank you.
Thank you. So I think that we have only time left. Unfortunately, this has been a great discussion, but unfortunately, we only have time left for a few more questions. So what I'd like to do is take one question from the chat and one question from a live question. And then I'm going to ask that each of the speakers address what they can with those questions and any last remarks that they have. The question from the chat comes from Elisabetta Galazzi. The question is, the opening of the investigation by the OTP for the crimes in Ukraine is the biggest challenge in the recent history of the ICC. Millions of victims will call for justice, including minors. What impact will this have on the functioning of the court? So to keep that in mind. And then I see that, Victor, you have your hand up. So if you'd like to ask a question, go ahead.
Thank you, Heidi. I'm very honored to be with you today and share this excellent presentation. My question would go to Shyamla. Shyamla raised a few very interesting issues we might need to discuss quite a lot in the ICCBA Executive Council soon, I believe. And my question to Shyamla would be whether she thinks that having a task force regarding the issues you raised about the children protection between the registry, the ICCBA, and the prosecutor would be a better option, or whether it would be better ICCBA to pursue different discussions with the registry and the prosecutor.
Great, thank you. Why don't we go in the order that we did the presentations? So Shyamla, if you'd like to answer either the questions, Victor's one was directly for you, and any closing remarks that you do have.
Thank you, Heidi. I think I'll just address very quickly Elisabetta's question. I think it's very important what she says, and certainly there are implications for the court. And because these are, it involves monitoring of ongoing violations as well, I think it'll be important to already have the capacity to monitor child-related violations taking place. So I would suggest that, priority focus be given to incorporating this expertise already in the respective organs of the court. And to address your question, Victor, is really, I think that this is an issue that you probably don't need a separate task force, but which I think the Victims Committee of the ICCBA can really take the lead on, as you have on today's event. And just as a final remark, again, to reiterate that this is a really important discussion, and to really commend everyone on the Victims Committee for giving it the priority that you have, and to everyone for attending this evening and staying on much longer. It shows how important this issue is for all of us to be discussing and taking further. So thank you very much for having me on this panel.
Thank you so much. Nikki, I think you're next.
I just want to echo, thank you so much for having me. I learned a lot by listening to the other panelists, and the questions have been excellent, and these are really important topics. Certainly, I'm happy to anyone who is dealing with a situation where they're interviewing a child for the first time. Feel free, you're welcome to give my contact information out to somebody, and happy to walk you through anything that would be helpful to you, and good luck and thanks again.
Thank you. Priscilla.
Thank you, Heidi, and thank you, everyone. I just want to emphasize that we cannot say we support victim participation without effectively equipping the representatives, because I think one thing that came out today is the fact that on one side, we want to see, like the child victims and the rest of the victim community effectively represented. But if the representatives and all the people that work together to do this are not fully equipped, if they're not trained to deal with the challenges they meet, if they don't have psychosocial support, then we are failing at the end of the day. You can imagine what happens if people continuously leave the role after a few months of engaging and you build rapport, then you have to leave. It wouldn't benefit anyone. That's my closing remark for now. Thank you.
Thank you. Joseph.
Yes, allow me to express my own gratitude to the Victims Committee for having me. And of course, thank you to all the listeners. My parting shot is that to be successful, in my experience, to be successful with representing child victims, you need to build trust with the victims. What we have done in the Dominic Ongwen case is that we have gone out there and sat with the communities, spoken to them about the activities of the court, fielded or answered their questions, and in so doing, consistently. In fact, as a matter of fact, we did have engagements monthly. And so we were in a position to build rapport, as Priscilla said. We were able to build confidence amongst the victims. And in doing so, they trusted us and were able to come out and speak to us freely about their experiences. I think that's very important.
Thank you. And last to Sahar.
Let me thank you all for having me today, and thank you, Victim Committee, for organizing this wonderful event. And my final remarks is that this is a very important topic, not only for the lawyers as well as the judges. So I suggest that my final remark is that to continue this dialogue, to have a kind of a uniform and the universal approach of obtaining evidence of child witnesses. I think that we had to discuss further about whether we can come to a universal approach about the competency, whether based on the sworn or the understanding of the truth, or letting them to express their view and let the judicial office, the court to decide the truthfulness. So that is my final remark. Thank you for everyone.
Well, thank you very much. That is going to conclude our program for tonight. Thank you so much to the speakers for your excellent presentations and for the discussion afterwards, and for everyone that attended today and for all of your questions as well. I think this has been a very insightful conversation and presentations from everyone. I want to say that the ICCBA Victims Committee will be planning another webinar, hopefully in the coming months, on a topic that will again help victims representatives at the ICC and navigating representing victims before the court. So we'll certainly advertise that when that is planned. I would also encourage anyone who's here today who is not a member of the ICCBA to please go to the website and consider joining and becoming involved with the ICCBA. It's not only for those practitioners before the court, but anyone that's interested in the work that the court and counsel and support staff do at the court. So please do join if you're interested. So thank you very much again to the speakers and to the audience today, and hope to see everyone again soon in another discussion.